Planning Board is now in session. Good evening, everyone. First item on the agenda is proposed warrant article, public hearing. This is the bylaw change, removal of section 174-10G, appeal of site plan approval to the ZBA. I'll ask the town planner to read the public hearing notice. Karina.
Okay, notice of public hearing, Town of Southborough, amendment of zoning bylaw, Chapter 174 of the Code of the Town of Southborough, Massachusetts, with regard to Section 174-10G. In accordance with Massachusetts General Laws, Chapter 48, Section 5, the Planning Board of the Town of Southborough will hold a public hearing on Monday, March 12, 2018, at 7 p.m. in the Thomas J. McAuliffe Hearing Room, second floor, Townhouse, 17 Common Street, Southborough, Mass., to review a proposed warrant article for an amendment to the zoning bylaw, Chapter 174 of the Code of the Town of Southborough, Massachusetts. The proposed zoning amendment will delete the existing text in Section 174-10G in its entirety, which specifies any person aggrieved by the action of the Planning Board on a site plan approval application may appeal said action to the Zoning Board of Appeals as provided in Article 6? Is that a 6, right? Thereof. A copy of the proposed language can be viewed in the Planning Office, Southborough Townhouse, 17 Common Street, at the Southborough Public Library, 25 Main Street, Southborough, and on the Southborough Town website, southboroughtown.com/planning. It is also available at the Town Clerk's Office, 17 Common Street, Southborough, Mass. Any person wishing to be heard on the proposed change to the existing zoning bylaw should appear at the time and place designated. This legal notice is also posted on the Massachusetts Newspaper Publishers Association, MNPA website at masspublicnotices.org. Donald C. Morris, Chairman, Southborough Planning Board.
Thank you. The Planning Board holds the public hearing for proposed articles that have to do with zoning, regardless of who the proponent is. And in this case, the proponent is, or the sponsor is the Board of Selectmen. So I'll ask Mr. Shea to start us off. Good evening, Mr. Shea.
Okay. Good evening, everybody. Thank you. So yes, the Board of Selectmen is proposing this article. And this article has come about as a result of feedback that we had received during legal proceedings associated with the Park Central project. And it was feedback that was offered to Town Council that the process that we have in place in our current bylaws is not common, it's unusual with respect to what other communities have, and it was then questioned. And Town Council then brought that information back to our board. We've yet to take a formal vote on this as a board, but we did want to move forward with this as an article at the warrant at the upcoming town meeting to put this in front of the people in town to see if they want to make this change. From my perspective, speaking individually, I think it makes sense. I think that ultimately we need to, as a town, need to make a determination as to what authority in town has the final say on site plan approvals, and in my opinion, that authority ought to rest with the Planning Board. So I think that from that perspective, I hope that this article passes. I would like to have Town Council come up and give additional insight onto the feedback that he received during the matters that he participated in, and just give a little bit more background and insight into the article. Thank you.
Thank you, Mr. Selectman.
Good evening, Council.
Mr. Chairman, members of the Planning Board, good evening. It is true that this is the second time now that courts have commented, while I've been in proceedings, on provisions of our zoning bylaw. One several years ago had to do with an issue of interpretation relative to our over 55 provisions, and the fact that a municipality can, under zoning, can regulate use, but you can't regulate ownership. And there was a provision in there that was conflicting with that legal theory, and that was pointed out by a judge of the land court. And in turn, I believe that we went to town meeting, but people had indicated, well, let's wait to see how the appeal goes in the next higher level. Well, the next higher level, which was the Mass Appeals Court, upheld land court and upheld the interpretation that that particular provision was unenforceable. It is my responsibility as the town council, anytime a court of the Commonwealth makes a commentary of that nature to me as your general town council, I have two choices. One, I can simply say, well, okay, I'll just remember that and that'll be that. Or, I believe it's my responsibility to identify the issue to the town I represent and the regulatory boards, and at least give people an opportunity to address that which the court has indicated. And in this particular case, we had a different land court judge. It was an appeal relative to the denial of site plan approval on Park Central. And in the discussion in the case management conference, the first step in land court proceedings, the judge questioned the developers' counsels about the basis of the appeal, and then turned to me and said, Counselor, this appeal of the decision of the planning board to the zoning board, which I call a lateral appeal, it's an internal appeal in government. She goes, that's rather unusual. And this was Judge Shire, the former chief judge of land court. And I said, yes, Your Honor, it is an unusual proceeding, but it's something that was put into the bylaw. And she goes, okay, but she goes, I see that as just an unusual process. And I says, yes, I believe you're right, but it's something that is in the bylaw. Well, when that judge of that caliber says that to me, it's got to be addressed. So when I presented this, I basically had indicated that when I was in the proceedings with the zoning board reviewing your decision, I noticed really an uneasiness with most of the zoning board trying to delve into the issues of an incomplete site plan. And that's what the whole issue was on appeal. The inability or the declination of the applicant to giving the planning board sufficient detail to make a decision on the site plan. Very unusual situation, but a basis to deny. So in any event, having seen that, the conclusion I drew from that uncomfortable situation with the ZBA and the commentary of the land court judge that this town would probably be best suited to return to what has happened since the 1980s or 90s, I think. Actually, no, the 1990s, because I can remember as a selectman in the 80s, we had site plan review, and I didn't understand why 3 selectmen had site plan review. And apparently, somewhere in the 1990s, that changed, and that was the way to do it. Site plan review does respectfully not belong to the Board of Selectmen, and it doesn't belong to the Zoning Board of Appeals. It belongs with the Planning Board to be decided by the Planning Board, and if it cannot be resolved in an administrative proceeding before the Planning Board, then it can go to the courts of the Commonwealth. That is the most appropriate place in Southborough for site plan review. So that's the genesis of why I propose this to the Board of Selectmen. If you have any questions, I'd be glad to address them.
So, thank you, Aldo, for that background. And, you know, you read the section in the code and the code number and all that, and you can get lost a little bit. But the way you've explained it, it's really a very, very simple change. Either the people agree with it or they don't.
It brings us back to the provisions that we had for many years before that change was put in. And I've heard people say, well, what happens to other sections? Admittedly, there is the other section that has been identified that relates to discussing including an action of the Board of Selectmen relative to a zoning permit, a site plan. That's obsolete. I discussed amending or modifying that, which is really a separate issue because it has no legal effect, with the town administrator, and the thought was to get this issue cured. This is a more substantive of an issue, to cure. Get this one cured first. You know, if you recall, Southborough had a comprehensive zoning bylaw review with consultants several years ago. Comprehensive. And I had to review all of the potential changes that were made. Unfortunately, that went nowhere. It just didn't take effect. And now we see situations where, on occasion, something that is compelling, even though it's a pick and choose, if it's that compelling, you got to address it. And the most obvious zoning change, which was done in a segregated way without a comprehensive change to the bylaw, was striking use variances, which had no place in Southborough's bylaw for the last 20 years. So that's more the background on it.
Thank you. I'll open it up to the board. Mr. Mills?
No questions at this time. It'd be interesting to hear from the public, or if the ZBA had any comments.
Mr. Jenks?
Elder, you mentioned 2 issues raised by the courts recently. Why do you choose to bring this one forward?
Well, I've actually brought both of them forward in the last 3 years. The other one had to do with a different appeal relative to over 55 provisions in the bylaw. That was about 3, maybe 4 years ago. This is the newest one. So I haven't picked and chosen, I have done both. And if there was a third commentary by a different judge on a different case, you would know it, or the town would know it.
But we haven't made a change to the age issue, have we?
No, because it was rejected at town meeting, because the commentary was by some that we should wait to see where the appeal goes. And I said, regardless of where the appeal goes, it should be stricken. Well, town meeting decided not to strike it. The appeal failed, and the original decision of the land court that identified that as an issue stands.
I agree this was a crazy process, made only crazier by the fact that the appeal to the zoning board of the planning board's site plan decision didn't include the planning board as a party. So we could have gone in individually or as a board, but we had no formal role when a developer, for instance, filed an appeal of our site plan review decision with the zoning board. And in all due respect, that's a board that doesn't deal with site plan review, and I would think that board would be happy to see this pass. I certainly would. Does this affect the rights of a neighbor to a project to have a very inexpensive avenue to go for another review, maybe just to air the issues? That zoning board review was far more informal than a court review. And I know there have been, I remember one occasion years ago when a neighbor just wanted to vent some thoughts that wouldn't come out in the court review. Do they still have a right to go to the zoning board for an appeal? And does this just take it out of the administrative process that you have to satisfy before going to court?
That's a very good question, and do you mean there, as an abutters, right of appeal of a decision they don't agree with as to the planning board?
Correct.
I would say that the resolution of that issue, because these are public hearings before you, and with the knowledge I have of the planning board's ability, residents' issues should be, remember, the applicant is normally a developer, sometimes a neighbor, and if it is a neighbor, I know that the planning board acts maybe a little differently to be reasonable, especially if a resident is coming in with a proposal, but you listen to everybody. The real issue is when a developer comes in with a team and makes a presentation. During that administrative review process, the abutters should be given adequate opportunity to address the issues and convince the planning board of maybe amendments, modifications, conditions relative to the plan. But independently, both the developer and the residents would still have whatever rights exist under Chapter 40A. Remember, this provision was only put in maybe 10, 12 years ago. Before that time, there was site plan review, and people had the same rights then that they would have now under the amendment.
So I think you're saying there would be no one could have the right to go to the zoning board to appeal site plan decisions.
Correct. They would anybody would have to go directly under 40A or under a different statute, which we know as certiorari, to be heard in the courts of the Commonwealth. But again, the real issue is, can the matter be resolved before the planning board? This is site plan review. This is the adjustment of a plan to mitigate the effect on a neighborhood. And the most qualified people to do that in the town of Southborough is the planning board.
But there are almost always people who are happy with the decision and people who are unhappy with it. And I'm talking about the people who are unhappy, who today can, for very little expense, if any, go to the zoning board to open an appeal so that they can express disagreement with the planning board, things they couldn't get resolved, and we're taking that away from them. And I'm wondering if it shouldn't be either or. Take the zoning board out by saying it's not a requirement. You can skip that and go right to court, but leaving it in there for neighbors who might want to. I don't know there's a lot of that, but even some.
That kind of creates a regulatory review that's upside down on the intent of 40A. 40A is the operative statute that allows all of this to happen, whether it's internal or directly to the court.
Well, excuse me for interrupting, but
Sure.
I'll have to state my opinion that 40A didn't do much good with the town's process of Park Central,
On what permitting?
the whole use variance issue.
I said several years ago, in a town meeting, several years ago, before it was defeated recently, in conjunction with your town planner, Vera Coleus, that this should be defeated and stricken from the bylaw. And I don't mean to do hindsight, but if the town meeting had decided then, and that's in the record, several years before Park Central, then we would not have had half of the Park Central issue. And I think that some of you are aware, because I think the planning board was trying to also speak in favor of striking that use variance. Unfortunately, the town meeting at the time, late in the last evening, defeated it.
If I could, I want to make sure that we stay focused
Sure, I understand.
on the intent of the article, and I'm very glad that we're kind of using Park Central that experience as an example, recent example of a good reason to have this changed. But we want to make sure that we're not doing this because of Park Central. We're doing this because a judge brought to your attention a situation that didn't seem right. And the way you explained it to me initially, Aldo, was that the appeal should be, as you said earlier, the planning boards in the towns are the most qualified to perform the site plan review. And the way you explained it to me, the court had a problem or a serious question with an appeal process where you appealed to another board that is less qualified. And that's really the issue here. Yes, the planning board's the most qualified in the town of Southborough, but the courts, what we see is our own zoning code and our own site plans. The courts see zoning codes from all over the state and multiple site plans. And apparently, in the court's opinion, that it may not be a perfect world or a perfect thing, as Mr. Jenks brings up, by having it go straight from the planning board and not being able to appeal within the town at low cost. It's the lesser of the evils. You're appealing to an authority that has the expertise to hear the appeal, rather than, as you said, a lateral, what was the term, lateral?
Lateral regulatory appeal from one board, one town board to another, planning board to ZBA. And and everything you just said, I think is accurate and correct. You know, I represent and have represented the Zoning Board of Appeals many more times in Southborough than I have the Planning Board, by consequence. And this is no reflection by me on their ability as it relates to the principal responsibilities of the Zoning Board of Appeals, which is to grant variances dimensional in nature under the bylaw, to hear administrative appeals if residents are not happy with the interpretation of the building commissioner, or to grant expansions of non-conforming uses, which is a type of permit, as you know, or special permits under their jurisdiction. They are fully qualified to continue to do that, and they are probably the most powerful board in the town outside of the Board of Selectmen in that regard. But it's just respectfully that site plan review is more in unison with subdivision plan review for a planning board and then giving it to a zoning board.
Mr. Jenks.
Can we hear the zoning board's opinion of this change?
I think once we get down the table, I would ask to have Mr. Dennington speak, because I can see him sitting there and we want to hear from him. If you're all set, we'll go on to Mr. Stein.
I am, and I'll just finish with saying I am in support of this.
Mr. Stein.
So, other towns, do any other surrounding towns, or any towns in the Commonwealth that you're aware of have this system of an appeal to a ZBA of a planning board site plan review?
None that I know of locally, or that I've dealt with locally or represented. I never did a search statewide, but I think that the chairman of the Zoning Board of Appeals has a little bit more information in that regard.
Okay.
No, it's an unusual process, and believe me, the land court judges, in my opinion, are the level of federal court. They are the highest qualified judges, and when they make statements like that on land-based issues and disputes, any council should be listening very carefully and at least bring it back to the town and let the residents at the town meeting make the ultimate decision. But again, I felt that was my responsibility, and I'm firmly behind the need for this change, but I defer to the legislative body of the town.
Is there anywhere else in the town code that needs to be revised to keep consistency with this change?
This was raised by one of your members, Mrs. Luttrell, and it had to do with Article 6, which refers to the appeal process, and makes reference in this provision. That provision, if you read the sections of 40A, really pre-existed this provision that we're considering to strike, and that language was intended for administrative appeals by residents to the Zoning Board of Appeals relative to a zoning enforcement officer's decision. The only part of that should not really be tampered with, because that is clarifying an administrative appeal process that's in state statute, except for the phrase that references boards of selectmen or the Board of Selectmen having site plan review or zoning permits. It's true, when I was a selectman in the 1980s, we had it, but it's obsolete. But it's of no legal effect one way or the other today.
Should we not incorporate that into this warrant article?
I actually created a change and discussed it with the town administrator, and the thought was to focus on this significant change. That's really just housekeeping. That's cleaning up an old provision. I mean, to be honest with you, if you go through that bylaw, there's a lot of different provisions that need to be cleaned up, but the town was not ready several years ago for a comprehensive zoning change. So we deal with the issues as we find them, as they are needed to be addressed, use variances and the like.
So how would the passage of this warrant article affect Park Central or any other previous planning board actions?
It would not. Those are all, that appeal remains, because that appeal was taken under the provisions at the time. It would just not permit in those particular cases, similarly situated developers from taking an internal appeal to the ZBA. They would be compelled to take their appeal of the decision of the planning board to the courts of the Commonwealth. And keep in mind that I said to you a long time ago, the rejection of a site plan by a planning board, the level is high. The plan has to be untenable. It has to be so poorly constructed that it just makes no sense. Or implicit in that process is the inability, refusal, or declination of the applicant to give information requested by the planning board. Anytime that happens with any board, conservation, zoning board of appeals, or otherwise, when somebody says, we're going to stop giving you information to make your decision, then they've just cut off your ability to make an intelligent administrative decision. And the only recourse for a board of that nature at that time is to say, well, if that's what's going to happen, denied.
So I fully support this. The site plan review process, as I've experienced it and how it's outlined in our town code, does allow, in my opinion, for all residents to participate, let alone abutters. So I feel the site plan review process is more than fair and open. And we've been very patient and thorough in our site plan reviews since I've been on the board. So I fully support this warrant article.
And that's proven by the fact that you really only had 2 appeals. One was Stowe Road, which was Fay School and the neighborhood concerned, and that was settled out. And then the most monumental development issue, Park Central.
Mrs. Luttrell. Don't go anywhere there.
Yeah,
Counsel.
no, yeah.
Yeah, what was that?
I thought I preempted your question by answering it in advance, but go ahead.
So there've only been 2 appeals
To my
of the
knowledge.
site plan
To my knowledge, internally between the planning board and the ZBA.
to the ZBA?
At least in my experience for the last 16 years, those are the only 2.
Okay. Are any other planning board decisions appealable to the ZBA, like special permits or subdivision?
No, absolutely not. Subdivision control is your most powerful statute, that's Chapter 41. That goes to the courts of the Commonwealth. There is no other appeal.
So
There's
it was,
no other
it was
internal
only the site plan?
That's correct.
Okay. My question with 17425A1 says, any person aggrieved by any order, decision, or failure to act believed to be in violation of state zoning act or this chapter may appeal such action or failure to act to the Board of Appeals. And I'm wondering if that would be in conflict, because this would be a decision relating to this chapter.
I'll tell you why it isn't, because that provision was in the bylaw, to my recollection, before the change. And as I said earlier, that is just a general commentary of the ability to appeal, people to appeal decisions, particularly as they relate to administrative review. That's really, by going to 48, 8, 14, and 15, that means zoning enforcement officer. If somebody's not happy with them, and those cases are on appeal right now, then they have the ability to take their position on something they disagree with relative to his decision directly up to the next highest zoning authority, the Zoning Board of Appeals. You wouldn't want to tamper with that at all. That's just restating state statute. As I say, the only part of that which is obsolete and of no legal effect is the phrase, including the action of the Board of Selectmen relative to a zoning permit or site plan, because that doesn't happen anymore.
So you wouldn't want to put except site plan in there? I'm just wondering if, I've seen many talented attorneys, and are they going to look at this and say, well, this is in conflict with the other section of the bylaw because this says any decision?
It says any person aggrieved by any order or decision.
Right.
Or failure to act, correct. But it relates to those sections of 40A. That is administrative appeal from a decision of the zoning board, of the zoning enforcement officer to the Zoning Board of Appeals. That's what that means. And that predates the change in 17410G.
Okay, I'm just wondering if it would be cleaner just to put except site plan in there.
I wouldn't tamper with that, because I think that's been around for quite a while, and I understand perfectly well what's intended. If we're going to do anything in the future, we just need to get rid of strike the phrase, including the action of the Board of Selectmen relative to a zoning permit or site plan, because they don't do that anymore. They haven't done it since the 1980s. But it's harmless, and at this point, we're trying to get rid of or to modify that which has been identified as an issue.
Okay, thank
Okay.
you.
You're welcome.
I see we have the chair of the ZBA here. Mr. Dennington, did you want to speak? Good evening, Andrew.
Mr. Morris, how are you? Andrew Dennington, 10 Carolyn Terrace, and I'm just speaking in my own personal capacity. I don't think there is a ZBA position on this, but I've just been interested in it and have reviewed this. And in general, I am in favor of this, so I would like to see, the intent of this is to eliminate this parallel interagency appeal, and I think that makes sense. On the train ride out here, I just noticed there's actually a chapter in the MCLE Mass Zoning Manual that deals with this exact topic called, it's a collection of cases about how do you appeal a planning board action on site plan review. So it looks like there's some uncertainty in the law, and so I think there might be some things you could do to clarify this. And I agree with some of the comments Mrs. Luttrell has made about ways we can make it even more clear. But generally, I'm in favor of it because I think it promotes comedy between the planning board and the zoning board of appeals. Mr. Jenks, the way you phrased it, that we're less qualified to do site plan review. The way you phrase it kind of hurts my feelings, but I agree with you. I think that the idea is that this is a field of endeavor that you specialize in. By statute, we have other things that we have expertise in. So this interagency appeal, I think creates some kind of friction that's really not necessary. So in just I've only been on the board for 4 years, but I have sat on the 2 appeals that have been taken under this section, and they're both very bizarre, because this appeal comes, and for anything else, when we act on a special permit, a variance, 40B comprehensive permit, there's a clearly defined legal standard about how we proceed. Under this interagency appeal, there's no standard. I really do not know what we're supposed to be doing. So, for example, on the Stowe Road, the soccer field case that involved the soccer field that's run by Fay's School, to me, I felt that was just one of the abutters was just had a kind of brought the matter to our board just to try to get kind of a slightly better deal. I saw nothing fundamentally wrong with the way that the planning board had approached the site plan review. And, you know, were we supposed to kind of step into your shoes and act how we thought you should have acted? Or were we supposed to review it to see if there's something fundamentally wrong with it and just affirm it unless there was something totally wrong with it? So I wasn't really satisfied with how that happened. It was nice that the applicant and the abutter this prompted a settlement, but why should this interagency review be used to prompt settlements like this? If there's nothing really fundamentally wrong with how the planning board approached a site plan review, I don't see why there should really be an interagency appeal. So, you know, this has been prompted by the whole Park Central affair, which is so long and drawn out and convoluted that I agree, you have to be sensitive about, you know, using that case as an example to rewrite, you know, the whole law in the town. But that was something very different where just legally, you know, there are differences of opinion on the board about how to approach that appeal, but at least in my view, I saw some serious legal issues that were presented by the planning board's denial of the plan, which is a much higher hurdle to sustain. So in that case, I think it makes better sense and it promotes comedy to have, if that's the planning board's decision to, I think you should be a party to the appeal and you should be just directly defending your decision. You know, if there's a major issue, this interagency appeal kind of makes it our problem, our issue. And there, the option, the statute, I'm sorry, not the statute, the bylaw says, I think that we would have the authority, we could either affirm it, deny it, or we would have the same authority you did to go into the issue all over again. And that doesn't feel very satisfactory either, because there were hours upon hours upon hours of hearings on that site plan review that you did. Should we then start from square one and do the whole thing over again? That didn't seem very appealing to me. So I also watched the videotape of your initial hearing on this a couple of weeks ago, and also the Board of Selectmen's hearing. So in terms of what other towns do, I had just informally polled some of my law partners who also work or volunteer on their own town ZBAs. So my partner, who's I think the former head of the Manchester ZBA, has never heard of this interagency appeal. My partner that who was on the Newton ZBA, never heard of this. My partner is the former head of the Winchester ZBA, never heard of this. It is kind of unusual. And I applaud Mr. Cipriano for, in response to a judicial comment about an unusual bylaw, taking some affirmative, proactive action to do something about it. So another comment that's been brought up in some of these hearings is kind of a concern for the little guy. You know, are we doing something to hurt in a butter that just wants to take a cheap appeal of some smaller aspect of the site plan review to the ZBA? I have never seen an instance like this, and I think there haven't been any in the 10 years that this bylaw has been in effect. So it sounds like we're really addressing a problem that isn't really a serious problem. I agree with Mrs. Luttrell's comment that it makes sense to me that if really the intent is to provide, to provide for a direct judicial review of planning board action on a site plan or approval, why not? There's ways we can say that expressly to clarify, so that there's no confusion about this, to eliminate other parts of the bylaw that might be inconsistent with it. And the part of the bylaw which talks about Board of Selectmen action on site plan approval, that's a dead letter, but it would be great to strike it completely, but I understand that shouldn't really hold this whole thing up. So really in conclusion, I personally am in support of it, and conceitedly, this is just based on some research I did in the last 1.5 hours about, I noticed some towns have bylaws that say any person aggrieved by the action of the planning board their action shall be, you can immediately bring an appeal under Chapter 40A, Section 17. That would say exactly what we're trying to do here. So, but I understand that at this point in the process, I don't know if we can consider changes to it. Maybe it's an amendment at town meeting that you could support. But I am a little bit concerned that just this statute alone would actually still leave some uncertainty. And even though it's the clear intent to provide a direct judicial right of appeal, we wouldn't want to leave any ambiguity in the bylaw. And why not say exactly what you're intending to do?
Thank you. And I think the town should thank you for your good use of your time on the train. Before you, Sam, I want to go back to that last point, which was, if we put out a public hearing notice, and correct me if I'm wrong, but if there are changes to the proposed warrant article that makes it more restrictive, can we do that after we've publicized the public hearing? I know that we've made changes that leaves it the same, leaves an article essentially the same, or makes it less restrictive. But if the Mrs. Luttrell proposed changes were to be added, would we risk having the Attorney General say that you increased, you made it, what you did was greater than what you initially proposed to do, and therefore the whole thing is thrown out?
That was a very good point relative to an affirmative statement of 40A-17, but I don't think so, and the reason why I don't think that would be a problem is that, as I've said earlier, that process, I think, is inherent in the other provision that we discussed in Article 6, the appeal process. There is also the ability outside of 40A-17, and something that's called certiorari, which just affects the fact that there's no other appeal available, but you want to get to court, and that's available. But I don't think by clarifying what is already in existence, the ability to take a judicial appeal, and even putting those words in there, would create a problem of interpretation as to going beyond the scope of what was being reviewed. Because it's in there implicitly, what you're doing is you're making it explicit. So if that's the way you wanted to do it, I mean, I saw that as it's sufficient in there because it's been used historically since the early 1990s. But it would not hurt to add a phrase that affirmatively indicates the appeal right under 40A Section 17. And I don't think that would in any way be challenged because you're just simply clarifying what is in the four corners of the bylaw.
So would the next step be that we ask Mrs. Luttrell to work with the town planner to find the words to submit to you for the final warrant article language?
If you could do that, I mean, that's one option.
How else would we do it?
You simply direct me to put it in legal form.
Does the planning board have any objections to having, that'll be the next step then? We'll ask you, counsel, to do that through the selectmen, of course.
And we would do that, but that, keep in mind now that the... Just excuse me, sir. With the warrant closed, that would have to be an amendment on the floor. Because I don't think the Board of Selectmen is going to reopen the warrant. So that would be...
To change the language of this particular...
Yeah, what you would do is,
Yeah.
remember, the planning board's to give, should give report under the statute. So when you give report, you could simply say that based upon what developed in the public hearing, the recommendation is that a modification be made and add language, and I will be glad to explain that it's simply clarifying what exists, and then that can be considered by the town meeting. That's the only way, that's the only real way you can do that. If you wish to go that way, if you don't want to touch it at all, I'm still okay with it, but that clarity does not hurt.
Sounds like that's the way everyone wants to go at this point. And that's one of the reasons we hold a public hearing.
Right.
Sam, you were next?
Thanks. Sam Stivers, 7 Presidential Drive, member of the advisory committee, but speaking as an individual citizen at this point. I'm strongly opposed to this for a variety of reasons that I will articulate here. I hate to disagree with my friend Andrew, chairman of the ZBA. As many of you know, I was on the ZBA for 7 years and chairman for 4 years, so I've seen a lot of this from the ZBA side. I think an overriding concern here is the little guy, as Andrew pointed out. And it seems to me it's important to have a structure where people feel they do have an opportunity to be heard if they're aggrieved by something. I don't think anybody's suggesting that the planning board is not exactly the right place to do site plan. Planning board has the expertise, et cetera, to do the right job here. On the other hand, having seen that from both sides of the table, you're in a perfect world, it works fine, but the world is far from perfect. And so just about any time you get one of these decisions, as I think Mr. Jenks pointed out, somebody is likely to be aggrieved to some extent or another. And I think it's important to allow the average citizen to be able to get another opportunity to state their case in a way that for a few $100s and a couple of months of time you can get a decision versus having to hire an attorney typically when you go to court. And the courts often take a long time to get these things resolved. So I think that it's important to do that. And in fact, the fact that a judge said that this is unusual is not that a judge said it's illegal or it needs to be changed immediately. I guess I'm not embarrassed for Southborough to have an opportunity for individual citizens to have another opportunity to state their case. It may be unusual, but it seems to me that's a useful element of this. I think it also strikes me that this is not very well thought out at this point, because I read section 25 in the zoning bylaws, Ms. Luttrell did, that there is at least ambiguity there, and regardless of what the legal community thinks, how clear that is, I think if you gave that language to 10 citizens, they'd all read the thing the same way Ms. Luttrell said in terms of how that's written without the full legal context. So I think at the very least we ought to be cleaning this stuff up so the normal person can actually read that and understand what the intent is very clearly there, as opposed to having that language in section 25 inconsistent with what we now have in the site plan area. So I think that, again, it's an important opportunity for individuals to come back to another board and state their case. I agree with Mr. Dennington that the ZBA doesn't have the expertise the planning board does. On the other hand, I would point out that since I've been watching the ZBA for over 15 years, there's always been at least 1 or 2 people on the ZBA who have been in the real estate business, developers, builders, et cetera, who know how to read site plans and have some opportunity to weigh in with reasonable technical expertise. Again, maybe not everybody, but I think that expertise is there. I think another thing that's important is that the ZBA actually knows local conditions. And I don't know, I've heard a number of these judges over the years in various programs and other activities I've done, and they may be great lawyers, but certainly not all of them are great site plan reviewers in terms of engineering background, and very few of them, I think, know local conditions like a zoning board member would know in terms of relevant facts for a particular appeal. And the fact that this doesn't happen often, again, to me, is another sort of red herring, in the sense that I think it's important for people to feel they have an opportunity to do this, whether they use it or not, and people feel like they've got a chance to be heard. And I think that's, again, an important thing for people to have confidence in. So again, I think this is not quite ready for prime time, even in its current form, and I think in concept it's not a good idea, and until a court says that it is illegal and you've got to change it, I think it's something we ought to hang on to. And I'm going to work hard to convince my colleagues on advisory to not support this, and my fellow voters at town meeting to do the same. Thank you.
Mr. Stein?
So, Sam, do you not feel a little bit of sense of urgency to protect the integrity of the planning board's decisions on site plans that are going to be coming up before us very soon? I personally
Sure.
feel that at this time, it does make sense to support this warrant article, especially in light of the clarification that town council and Mrs. Luttrell just sort of came to in conjunction with Mr. Dennington's comments. It just seems a little bit odd to me that we don't that we're not seeing the need for action now, rather than delay, and maybe we'll,
Well, again, I agree with you that I think in a perfect world that is important, but I think there are enough opportunities for people, well, I think it's important to keep opportunities for people to have another shot at a decision. And again, I would argue that until we have to do it, I think it's important to leave that door open. And I think I value opportunity for individual citizens to get recourse higher than comity or whatever else you might be looking for in terms of consistency between boards. And the good news is that it doesn't happen frequently. And so I think that's, creates less pressure on me to do something right now. But I think for the optics alone, it's helpful to have people feel like they've got another shot. So depends on what you view as most important. I've heard enough of the individual citizens who feel like they haven't had an opportunity to be heard. And I think that's, to me at least, outweighs some of these other arguments at this point. So, thank you.
Mr. Bartolini?
John Bartolini, 4 Wyeth Circle. I thought I'd be the only one here tonight that would be against this, and I'm surprised that Sam and I are on the same page. Yeah, doesn't happen very often. But I don't think a lot of people realize how a site plan works. And when you're talking about the little guy, you're talking about the abutter, but you're also talking about little businesses. And as Mr. Cipriano pointed out, a site plan is pretty much by right, and it's just done with conditions. And we have 5 pages of conditions in our bylaw. And what trips this is a change of use. It's not just for new buildings, just for a new developer. It's for existing buildings. It's for existing businesses that may be here for 50, 60 years or longer. And what happens is if there's a change of use, you get into site plan. If there is a change in parking requirements or loading, you get into site plan. There's also something in there if you change the landscaping, you get into site plan. There are 2 different, the historic bylaw that we just passed is subject to site plan. So what happens is you get into a lot of different areas. You have a minor site plan, you have a major site plan. Minor site plan is tripped by some uses and by square footage. And then the major site plan is done by something different. A 50,000 square foot building has to get a special permit from the ZBA before it can go to site plan. So we've got all these things that intermingle together, and the only thing we can think of is Park Central, which did not get approved by the ZBA. It did not get approved by the planning board, and it went to court. It went to court a little bit slower than actually what the selectmen want to do, which is immediately go to the planning board and then go to court. So I agree with Sam. It doesn't hurt to have another set of eyes. It doesn't hurt to have somebody hear an issue that somebody may not like a sign versus somebody else that may like a sign. There are a lot of small issues here, that happen. Does minor site plan end up going to court, or does that go somewhere else? That's not really addressed here. Major site plan is something different, but anybody who's got a small business may end up finding themselves in court. And I think that this was put in, I remember my dad going before Mr. Cipriano when he was selectman for a site plan. And that all changed, and it all went to the planning board, and everybody agreed it should be with the planning board. And it was actually prior to before we had planners. And what happened was, I think this provision was left in here because at that time we had a lot of small businesses. And the small business guy is the guy that may find himself in court or may in fact not go forward with an improvement that everybody may want because it's gonna cost him too much money for whatever reason. And the ZBA may be able to have another set of eyes on this that may actually take some emotion away from the planning board and the proponent and the neighbors and settle something. My opinion is like Sam's, another month or two and a few $100s before the ZBA, I don't think is gonna matter. It appears that everybody, the planning board wants to have the final rule, which I can understand. The ZBA really doesn't want to meddle into it, and the selectmen are kind of saying, we've had enough of all this. And, you know, this past couple of years, I can understand that. But in general, when you look at the history of Southborough and how few of these actually get appealed, I don't think that it's a bad provision that's going to hurt anybody. I just think that a small business may get hurt more than anybody else.
Anyone else? We've been at this a little over, just about an hour. If there's no other questions or comments, would it be appropriate then to close the public hearing?
Make a motion to close the public hearing for the proposed warrant article bylaw change, removal of section, well, it's not the whole section, but, you know, 174-10G.
Second?
Motion's been made to close the public hearing and seconded. Any other discussion? All in favor? Public hearing is closed. Thank you all. Our next item on the agenda is the Killam Farms subdivision open space, modification to definitive subdivision. While town council is still here and listening to the public hearing notice to be read by the town planner,
Mr. Chairman, sorry, just a quick point of order.
Mr.
Are we to vote on whether or not we support the warrant article before proceeding?
We could do it at town meeting.
Okay, sorry.
We could vote whether or not to support it, but I think that the revisions that town council is going to work on and submit to us, and submit to the selectmen as a proposed amendment, we would then at a next meeting, or whenever that's available between now and town meeting, have a chance to look at it and then vote on the article and the amendment as presented at that time.
Thanks for clarifying that.
Thank you for asking.
So you don't have to continue it? You can close it, because there's no more public discussion.
The question is, can we close the public hearing? And basically, the public hearing is for the warrant article that was in writing on the screen tonight. Now we're talking about asking town council to prepare an amendment for which there's no need for a public hearing. We should all know the answer if there's an
No, no.
amendment.
I would say that this was the public hearing on that language. So that the language is simply going to make a reference to the ability to take a judicial appeal under 40A, Section 17. It's not going to say anything more than that, which I believe is already self-contained, but I don't know if you think you need a further public hearing, but I think it's been aired this evening, and it will be aired at the town meeting.
Exactly. Question was asked, and we got a good answer. So we'll ask the town planner to read the public hearing notice for the Killen Farm subdivision open space modification to definitive subdivision.
This is the public hearing for modification to a definitive subdivision, Killam Farms definitive flexible subdivision. In accordance with the provisions of Massachusetts General Law, Chapter 41, Section 81W, the Planning Board of the Town of Southborough shall hold a public hearing on Monday, March 12, 2018, at 7:15 p.m. in the Thomas J. McAuliffe Hearing Room, second floor, Townhouse, 17 Common Street, Southborough, Mass., to consider the application of the Southborough Planning Board for modification to a definitive flexible subdivision known as Killam Farms. This hearing concerns the condition regarding the open space parcel, Assessor Map 14, Lot 42, written in the approval of the Killam Farms definitive subdivision by the Planning Board and dated February 23, 1999, that the open space will be deeded to the town at the time of road acceptance. The Southborough Planning Board seeks to amend the condition of approval to deed the open space to a preservation trust and for the deed to include language that will protect the parcel of land shown as open space area, 7.57 plus or minus acres, on the plans entitled Definitive Flexible Subdivision Plan of Killam Farms, Plan of Land in Southborough, Massachusetts, and recorded with the Worcester Registry of Deeds in the Plan Book 739, Plan 64, the subdivision plan. A copy of the application and plan may be reviewed in the Planning Department at the Southborough Townhouse during normal business hours or on the Planning Board's webpage, southboroughtown.com/planning-board. Any person wishing to be heard on the proposed modification should appear at the time and place designated. Donald C. Morris, Chair, Southborough Planning Board.
So could you give us go over quickly the steps that have led to this modification, and the reason why we have to modify the approval to the subdivision?
Yes. 1 second. So as some of you may recall, back in the fall, we had discussions regarding the open space parcel at Killam Farms and what to do with it, because it's been kind of on the books for so long. So during that discussion, there was a recommendation that the planning board would file for a modification for this definitive subdivision on the referenced condition. So February 21st, we filed, as the town planner, I prepared an application from the planning board to file this modification, and we filed it with the town clerk. We did notify the abutters the next day. The legal ads were posted in the newspaper on February 26th and March 5th, and the information in the application package was distributed to all the town departments, including the Open Space Preservation Commission, leading us to this meeting this evening. Anything else you wanted me to add?
That one sentence, right, there's a, did you refer to that before? Because this is very, very simple.
Yes.
But
And I'll call it up here.
I guess at this point, we can, that this has been worked on for a while, and after considerable discussion between the town and the owner of the open space, which is Brendan Properties, it all came together with what's being proposed tonight. I certainly want to thank the Giblin family, Brendan, and before that, Kevin, in working so hard to get us to this point. And you can see on the screen, there's a 1999 letter from the town planner listing the approval of the definitive subdivision and the two conditions. And it's condition number 2 that deals with the open space, and you can see that it says it shall go to the town, and all we're doing is changing it from going to the town to going to
The Preservation Trust.
real simple.
Yeah, in addition, during the fall discussions, Brendan Properties prepared a deed referencing the protection of the open space based on the comments that were made by the planning board at the time. I believe the deed was reviewed by town council, who made recommendations for some revisions, and Brendan Properties provided those changes. They also provided information on the Preservation Trust, which culminated in this final quit claim deed that's to be used for transferring the property into ownership of the Preservation Trust.
So the planning board will be prepared with a lot more detail, if necessary, for the town meeting, if there are questions, since this goes back almost 20 years. And hopefully we'll be able to be prepared to answer any questions that about things that have occurred over those years and why it's taken so long to get to this point. But again, we'll be prepared for that, but I think we've provided enough information here tonight for to launch on through the public hearing. I ask council to stay in case there's any questions that relate to these legal documents. So open it up to the board and then to the public. Mr. Mills.
I have no questions.
Mr. Jenks.
No questions?
Mr. Stein.
No questions.
Mrs. Luttrell.
No questions?
Open it up to the public. Any town officials want to speak? Anybody else? Why don't you state that?
And we also did not receive any review comments back from any of the town departments.
If there's nothing else, I'll put it in the form of a question. Oh, Mrs. Luttrell.
Sorry. So with the plans that we have and that have, I assume, been filed on the Registry of Deeds, there is going to be no change in the plans?
Well, that is a lingering question I have. In the statute, I'm not sure if there's a reference to if the plan changes, then you have to add the note to the plan of the modification, or if it's just the decision that's changing, then you don't have to modify the actual, or put a note on the original plan. I wasn't sure how that worked. I believe it refers to if you're changing the plan itself, you would add a note. But if you're just changing the decision, I believe,
Yeah, I don't believe you're changing the plan. As a matter of fact, what I think's happening here is your condition that the open space be deeded to the town is changed simply. The same land on that approved plan is deeded to a qualified third-party land foundation. So all that I think I would expect is that the reference would be made in the deed and the modified decision would be recorded therewith.
thank you.
Thank you.
Are there any other comments or questions? I'll put it in the form of a question. Is this appropriate then for us to close the public hearing on this proposed warrant article? Mr. Mills.
I make a motion, we close the public hearing for Killam Farm subdivision open space modification to a definitive subdivision.
Second?
Motion's been made and seconded. Any discussion to close the public hearing? Seeing none, all in favor? Public hearing is closed. This was a procedural question. If this passes at town meeting,
I don't think it's going to town meeting.
oh, it doesn't go to town meeting. So,
That was before the old one.
okay, so is it, so now the town planner would prepare the modification decision that would note this change, and then decisions on site plans, subdivisions, modifications are usually signed by the chairman, which is me, and then submitted to the town clerk. And then, is there an appeal period for this, or is it? There's an appeal period.
There's always an appeal period.
There was with Four Hidden Meadow as well.
You're amending the definitive subdivision decision.
So the board should take a vote at this time, now that the public hearing is closed, to modify to modify that condition.
Yes.
And then that vote would be reflected in the written notice of decision that the chair would sign and submit to the town clerk after the 20-day appeal period from tonight's vote.
I believe so, and then subsequently recorded at the registry with the deed.
Sounds right, yeah. Mr. Mills?
Mr. Chairman, I make a motion that we modify the Killam Farm subdivision open space decision? Condition to read, the open space will be deeded to,
Hold on. Hold on. The Preservation Trust, Inc.
the Preservation Trust, Inc. The Preservation Trust, Inc.
Period.
Period. Okay. You want to, I don't want A, Massachusetts, blah, blah, blah.
We have a motion to modify, to change the condition from transferring the open space to the town
Do we have to reference the
originally
decision?
to transferring it to the Preservation Trust Incorporated.
Second?
Motion's been made and seconded. Any discussion? All in favor? 5-0. Town planner will prepare a record of decision, notice of decision, and be submitted to the town clerk after a 20-day appeal period. Next item on, thank you. Next item on the agenda is the Chestnut Meadow subdivision. While the town planner brings us up to date on this, we'll ask town council to take another seat. Thank you.
Before we get into the discussion, George, as you remember, I couldn't vote on the last time because of the Mullins rule. Are you okay with me sitting here silently?
Yeah, it's my opinion that the subdivision has been approved. So there's no issue now.
I just want to make sure.
Policy issue.
Okay.
We're not asking for an approval of anything. So no, I have no problem.
So as Mr. Connors indicated, this is regarding the already approved, previously approved Chestnut Meadow subdivision, which we approved back, do you remember the date, George?
I have it right here.
Special permit, November 21st, 2017.
November 21st?
October 30th.
In late October or early November, the planning board approved the Chestnut Meadow subdivision. And since that time, have been working on a performance guarantee / covenant. And that has been reviewed back and forth between the town planner, town council, and Attorney George Connors, who's also the engineer. Do you want to take it from here, Karina? And what we're expected to be doing with this tonight?
Sure. we received the draft covenant from Mr. Attorney Connors back in the beginning of January to get to town council for review, which happened, and town council had review comments related to information regarding the applicant's trust, Habitat Acquisition and Permitting Trust. Let's see what it says here. The entity, Habitat Acquisition and Permitting Trust. And then regarding the type of performance bond or security, that was the process that was suggested. And then also regarding the covenant's time frame. Typically, as indicated in the sample covenant that the town uses and distributes, there's a 2-year deadline for construction, and the proposed covenant indicated 5 years. So there is supposed to be some discussion based on why the applicant wants 5 years and town council's recommendation for 2, maybe 3 years. So that's what we're here to talk about. I believe the other items referenced in Attorney Cipriano's review letter could probably be easily worked out between council. That's what I have.
Turn it over to you, George. Good evening.
Good evening. Habitat requests that the time frame for construction be increased to 5 years, basically because it's a fairly complex job. There are 12 houses to be built after the road is in place. There's 1,000 feet of road. There's 1,000 feet of work on Chestnut Hill Road to install a water pipe and widen the road a couple of feet and relocate some guardrails if selectmen approve that. And certainly marketing 12 houses in that particular neighborhood are going to take several years. They do not want to finalize the road until such time as they've got all the houses in place. And it just seems to make more sense to have a longer period than 2 years. Additionally, the only other issue that I have is to note that Habitat Acquisition and Permitting Trust has not been set up at this time. There'll be a trust document and recording of that just prior to the execution of the covenant and signing the plans, which they will send over to us and we'll get to Aldo. In terms of the bonding, that's premature. They will work on that particular site for quite some time, and then when they go for lot releases, they will exercise the surety, of which a method has not been chosen, but I'm confident it would be a tri-party agreement. So my real request at this point is your consideration of a longer period of time for construction.
If we come to an agreement tonight on the period of construction, that's all you're asking for tonight?
That's all I'm asking.
All right, I'll open it up to the board. Just that when town planner went over this stuff with me in the last week or 10 days, it immediately brought to mind other developers who, I think there was one very recently that asked for 5 years and it was not approved because it was, it's not what we see in the industry at this point in this town or nearby, and it was denied. So I'm concerned that if we were to go there with this site, which is a relatively flat, open field, I hear you when you say those other components, which is the public way has to be modified and will probably coincide with or predate the finishing of the subdivision roadway, because our concern was that the heavy vehicles to construct the subdivision would tear up Chestnut Hill Road. And so the town has agreed to fix that one stretch, the straightaway stretch there, to accommodate all the construction vehicles and the heavy loads. So that is a little bit of a difference than what we've seen in other subdivisions and requests, but a 12-lot subdivision, maybe today is a big subdivision, but we've seen a lot bigger ones in the past that had shorter durations than 5 years. I'll open up to the board. Mr. Mills. Mr. Jenks.
Thank you. George, are you phasing the construction of the houses?
They'll be built in response to market conditions, but the entire road will be bonded at whatever point in time they choose to get a lot release. It won't be a portion of the road, it'll be the entirety of it. And I'm sure that that will be, A, after the water line and the widening of Chestnut Hill Road has taken place and put to a binder pavement, and B, that the interior subdivision roadway is at all its utilities and paved.
What do you see for timing for that work?
2 years.
Now, that's it for now.
Mr. Stein.
So I'm in agreement with our chairman as far as consistency and fairness with with past decisions, and I have just one comment actually unrelated to that matter, which is on page 5. Just would request that my title be adjusted from clerk to member of the Southborough Planning Board. Just a typo.
Okay. Thank you.
Mrs. Luttrell.
Have you requested to be on the Board of Selectmen's agenda regarding the road? You have, okay. Yeah, I agree with the other members of the board and with town council that, that the 5 years is inadvisable.
So if we take the usual 2 years and added the 2 years that you're thinking is needed for the town to get the road and utilities to a point where you can coincide your road and your utilities, we took those 2 years and added 2 years, comes to, I think, 4 years. Pretty sure that's the way that would add up to. So what the board has done in the past is for a 2 year, if something like when the economy went down the drain 10 years ago, the state even stepped in and made some changes there and extended permits. But the town is also, this board has granted extensions for extenuating circumstances. So I guess I'll air that out. If the board went with 4 years, and then if after 4 years you still needed more time for a good reason, then you'd probably feel confident that you could come in and ask for that. Mr. Jenks.
I think that would work. What is the longest time we've ever given for a project?
I think we've pretty much stuck to the 2 years, and then, if I remember right, there were more than a few times when the developers would come in and say, we had a bad winter, or the economy's so good I can't get any plumbers, so I can't finish the houses, and would grant a 1-year extension, and usually, if I remember right, it wouldn't go beyond that extra year. But in the past, we've had land developed off of existing public ways, and either those public ways could could sustain the impact of the heavy construction vehicles, and the project got done, or after the project got done and the developer was done and out of there, then the town would have to go back in for the next 2 years and fix the road. So in this case, because of the sensitivity to the really beautiful and primitive conditions on Chestnut Hill Road that want to be preserved, the town and the selectmen of DPW have agreed to this, all this work to be done. So I can't remember anything this extensive as a coincidental action or pre-action before a subdivision.
So just so I understand your advanced calculus in that calculation, you came up with a total of how many years?
Give me a minute. See, it was 2 years for the road, and then 2 years for the subdivision.
If I may,
Don't complicate this, George.
well, I'm going to simplify it. Subdivision is really the roadway and infrastructure. It's not the houses. And when the subdivision work is done, the roadway, you do it to a stage where you can continue to build the lots without damaging the road, the surface of the road. So you don't pave the surface, you pave the base. You don't put in the curbing, you don't put in the sidewalks until all your lots are done. Then you come back and finish the road. That is the time duration for that, either 2 or whatever years it is. The houses could be built over the next 10 years if you finished the road, paved it, put the curb in, the bounds, and did the as-built. So we're really talking about just building the infrastructure to service the 12 lots. The 12 lots take a long time to build, but they could be built theoretically, as they are off an existing road, over the next several years. We don't want to finish the road because it makes no sense to do that. That's why the extended period is requested.
Right, that approach to the project is pretty much the modern approach, where
Correct.
the town doesn't wind up at a point where the houses are now occupied and the neighbors don't want to pay to have it plowed, so they want town meeting to accept the road, and now the road's 3 or 4 years old, and it's all beat up, the curbs are broken, the pavement is cracked. And so lately, we've been doing it as you suggest. Get most of the houses built, certainly all the big stuff, and then finish the road.
And there's bonding in place at that particular point in time.
Right. Did that answer your question, Mr. Jenks?
Thank you.
Mr. Stein?
Mr. Cipriano, do you have any input on this as far as exceeding the 3 years?
I've always been of the position that you see performance. And if performance is had in a period of 2 years or maybe 3 years, and there is a need for an extension, you get to hear why. As opposed to you let it go out for a longer period of time, you have very little control over what's happening until later. So, I mean, historically, when I've represented planning boards, it's basically the report card. How are you doing out there? You're coming close to the 2-year or the 3-year period. Well, we've done this, that, and the other thing, but we are running into a couple bona fide issues. Come in and explain them to us, and let's talk, and we'll consider an extension. I mean, that's, again, it's absolutely an administrative decision, but that has been my experience for so many years.
So, Mr. Connors, do you have any response to that as far as us going with 3 years and then leaving the door open for reappearance and
Well, that's the way it's done in most communities. However, now, when houses are of such a value, lots are extremely expensive out in there. It's gonna take a while to address the market conditions. You'll see the road is in, and there'll be a bond at some point in time for the remainder of the road, the surface, the sidewalk, the bounds, and things like that. But you'll see that the infrastructure is working, operating, and in good shape. I will point out that the legislature recently extended timeframes under special permits by another year from 2 to 3. So I think that's the trend. And in terms of monitoring or report cards, there is the stormwater monitoring model that can be used to address the roadway. We have to monitor a stormwater system every year and submit a report to conservation. I don't see that there'd be any difference in that and the road. But as Mr. Cipriano states, most towns are too, and we just think that this makes sense at a longer period of time because of the market of the houses. They're very, very expensive out there, and because of the extra work on literally another 1,000 feet of road.
So when you talk about the market, this is a seller's market for real estate.
It is.
Okay. Can you just clarify that then, please?
Well, houses on the other side, lots on the other side of Fisher Street recently sold for $550,000. So those are gonna translate to houses that are well in the million range. And that market, as I'm to understand, is not a seller's market at that rate of 12 houses in 2 years. I don't think anybody would accept that logic. And certainly if you're not gonna build them in 2 or 3 years, you'd like to be able to control that with a longer period of time.
Mrs. Luttrell?
I think I'd feel comfortable with 3 years. We normally do 2, give an extra year, and then if there are issues, you can come back before the board, explain it, and ask for an extension would be my preference.
One of the things we've also seen is that some developers turn these into kind of a dragged-out process where they'll only build a few a year, and keeps the cash flow, and it keeps things busy. But what we found back when a lot of the town was being developed was the first few homeowners that buy the houses, they wind up living on a construction site for a couple of more years. The dust, the heavy machines, the noise, the backup alarms, and they just bought $500,000 house. They have a yard, they have kids, and we've had them come in and say, how long is this going to last? The guy's taking forever to finish those last houses. And we've actually brought some of the developers in and said, you got to finish these up. These people didn't buy a house to be living in a construction site. So that's kind of the downside of having it drag out too long. Entertain a motion then? Mr. Stein.
I'd like to make a motion that the planning board, accept the covenant for the Chestnut Meadow subdivision with the adjustment of the completion timeframe from 5 to 3 years on page 2, paragraph 6.
We're not accepting the whole covenant at this time. So the motion should be just limited to changing the number 5 to the number 3. Those other things that George went over and council mentioned are still open items, so the covenant's not ready at this point. Although George did indicate it would be a 3-party.
I think.
Right.
So moved.
So the motion would just be to change that number from a 5 to a 3.
So moved.
Second?
Motion's been made and seconded. Any discussion? All in favor? 4 to 0 to 1.
Thank you very much.
Thanks a lot. Thank you,
Night.
George. He abstained.
Oh, yeah.
I can see that it's time to move on to the next discussion. However, out of courtesy to town council, looking at the remainder of the agenda, does the board feel for any reason that we should keep him even longer?
Sure.
If he leaves, it's at our peril.
Well, in all seriousness, is there anything specific you want to talk about for the warrant articles? Or did you have any concern?
All set, council. Thanks a lot for sticking around, and thank you for helping us with the warrant articles earlier.
Thank you, Mr. Chairman, members.
Hold on, we got one question
I'm
from
sorry.
town planner.
The draft.
We're ready for action. I got my rover.
The town planner's going to walk you to the door. She has one question, but it's not on the agenda. It's not on the agenda.
Mr. Chairman, can I move for a 2-minute recess?
Second?
Motion's been made and seconded for a 2-minute recess. All in favor? 5 to 0. We'll see you in 2 minutes. Planning Board is back in session after a 2-minute recess. Next item on the agenda is other business properly before the board. We have the planner's report. Karina?
Okay, I have a couple of things. Looks like a lot, but it'll be quick. First, I just want to point out to everybody that the annual town meeting on April 9th, I've reserved a room, number 128, for 6:30, so that the planning board can have a meeting that evening prior to the annual town meeting. But note, our next meeting is scheduled for March 26th, here, in this room.
Say 6:30?
6 p.m., I'm sorry.
6, thanks.
6 p.m., right. That's correct, 6 p.m. Room number 128 at the Trotter Middle School for Tuesday, April 9th. Our next meeting is scheduled for Tuesday, March 26th at 7. Monday, I'm sorry, Monday. I'm totally messed up. Our next meeting is Monday, March 26th at 7 p.m., and we didn't continue any public hearing.
So it's possible that we may not meet on the 26th?
Possibly, if there are no items up for discussion. There are no public hearing, there were no applications submitted that could make the March 26th Planning Board meeting for public hearing. And we don't have any known discussion items at this point. But they may arise. Let me just check one thing here. I just want to confirm that on the calendar, April 9th is a Monday. Yeah. Okay. Yes. Yes. So just to clarify, we have a meeting scheduled on Monday, March 26th, here in the McAuliffe Room. Then the annual town meeting is Monday, April 9th, which we have a meeting scheduled for 6 p.m. at the Trotter School, room 128. Our following meeting to that would be April 30th, where we may have a potential site plan application coming up, major site plan in LID for 154, 156 Northborough Road. They may be ready for that meeting. Okay, just quickly, I have on the planner's report the Chapter 61 process. It went to another board where there was some minor format changes at Conservation. So the Chapter 61 process working group is going to meet again at some point just to vote on those format changes. But the content of what the planning board voted on for that process hasn't changed. So I guess once after the working group meets again, we can determine if it needs another appearance for the planning board or if it's just strictly format changes. Because we did draft a letter recommending that process to the Board of Selectmen by the planning board. 135 Deerfoot Road, there was a question about the zoning boundary. I have some feedback from Bowler Engineering that they did find that the zoning they showed on the map was an old zone line, but that the zoning line shown on the new A&R plan does not impact the frontage or the area, the lot areas. So they made a record memo, and I'll put that in the file in case there's ever a question. They also confirmed from their surveyor that there are no stone wall impacts for their lots there. Initially, they thought they were going to come before the planning board for the scenic road stone wall permits, but they had the surveyor confirm that those stone walls are not on public right-of-way. So that, I have that for the record too. The EMC Dell roadway acceptance roadway acceptance was in front of the Board of Selectmen on February 22nd, and they were, got approval as a roadway layout. So I think the next step was town council was working to get that all ready for the annual town meeting for road acceptance of Washington Street relocation and Coughlin Drive, the short section to Route 9. Yeah, let's see. Public safety building, they selected the name of the golf course to be Southborough Golf Course instead of St. Mark's. Most of you already knew that. Golf Club, sorry, Southborough Golf Club. Thanks, Tim. Just another quick note, Mass DOT's I-495, I-90 interchange project. They have a online website, which is also in a display at the bottom of the stairs here. It's called Wiki Maps, where people who want to comment on the project, if there's a problem, there's a way to go in there and you mark your comments and you can see if other people had the same issues with the reconfiguration, because they're in concept stage still. I believe they have 4 or 5 different layouts to reconfigure that interchange, and that's a form for the community. It's a format for the community to go out and leave their comments on the project if they choose to. I received some information from Tim Litt regarding Complete Streets info, which we'll be looking into in the near future to see what we can do with that and who deals with that. I just want to point out that the elections are coming up May 8th, 2018. Item number 8, Shopsy. I'm not sure if I mentioned this at the last planning board meeting, but Jesse Stein had attended not only Southborough's Housing Authority meeting, but also Board of Selectmen's meeting to promote recruiting a member. And we have a potential member, which Jesse was following up with.
So just to be clear on that one, that was a resident that was not a member of the Southborough Housing Authority.
Correct.
And I did email the person. I have not heard back.
Right. And that would be for a member at large, not a required Southborough housing. But at least a lead, some form of lead. So we're still looking for people who are interested in being on the Shopsy. We are currently interviewing with candidates for the business admin position for the planning board. So we're working on that right now. We're hoping to have a favorable outcome in the next couple weeks, but that's still in the works. We had 30 applicants, 6 potential candidates, and 2 shortlisted.
Where are we with those 2 people on that short list?
We're just currently talking about benefits packages and terms of possible employment, background checks, those kind of things.
And that's just a planning board employee?
Yes. Planning department. Yeah, the EDC is still continuing to search for their own position, their own coordinator. And I already talked about the annual town meeting. We have the room reserved. And that's it. The meeting minutes are pending. I'm still working on them. I'm hoping to have them by March 26th if we have that meeting. If not, they'll definitely be ready for the 9th of April. That's all I have. Any questions?
Motion to adjourn.
Do you have any, Don? You looked serious.
I was thinking.
Second for discussion.
Motion's been made and seconded. Discussion.
Did we cover all the warrant articles that I thought that there was more.
You kind of talked to, I could hear what you were saying, that there was just a placeholder, but I don't think they could hear it.
Oh, do you want me to still talk?
No, I think-
Still in the meeting?
Yeah.
We're discussing
He wants to know
adjournment.
why we didn't talk about all the warrant articles.
Oh, I left that as a placeholder discussion in case something popped up or a question. If a
Okay.
planning board member had a question on the bylaw change or the RKG invoice that we have to go through town meeting,
Okay.
or the Dell EMC roadway acceptance, those articles.
Thanks.
Motion's been made and seconded. Any more discussion? All in favor? We're adjourned. Thank you.